Please rise for the pledge to the flag. States of America, to the republic which stands one nation under God, indivisible, with liberty and justice for all. Thank you. Did anybody see Katie with the arms on?
I don't know. I had sent him a reminder yesterday. I talked.
Okay. Sorry.
Okay, we're going to hand the hearing over to Solicitor Kelsey.
Okay, this is the time and place advertised and set aside for a hearing with respect to a proposed amendment to the Cumru Township zoning ordinance of 2009 as previously amended. For purposes of clarity, this text amendment to the ordinance was proposed by the Board of Commissioners and was not pursuant to any sort of application or request from any landowner or developer, nor was it proposed by the Township's Planning Commission. To begin, just so everybody is aware, we are on the record. There is a court reporter here taking down everything that anybody says. So there will be a transcript of this hearing that will be available later if anybody would like to see it. So to start, I'd like to mark some exhibits for the record. Township Exhibit 1 will be a copy of the proposed amendment to the Cumru Township zoning ordinance of 2009. Township Exhibit 2 will be the proof of publication of the notice of this hearing. For the record, this hearing was advertised in the Reading Eagle on February 3rd, 2025 and February 10th, 2025. Township 3 will be the affidavit of mailing of the proposed zoning ordinance amendment to the Berks County Planning Commission and the Cumru Township Planning Commission. Township Exhibit 4 will be the affidavit of posting of the notice of this hearing. For the record, there is no requirement within the municipality's planning code that a notice of a hearing with respect to a text amendment to a zoning ordinance be posted on any parcels that would be affected by the amendment. However, since this amendment does include the removal of certain permitted uses within the mixed-use general commercial zoning district, the township felt that it was prudent to also post the affected properties prior to the hearing. So in an abundance of caution, that was done. Township Exhibit 5 is the affidavit of mailing of the notice of this hearing to affected property owners. And again, there is no requirement within the MPC that this be done. But in order to, out of an abundance of caution, the township decided to also mail the notice of the hearing to any affected property owners due to the change in permitted uses within the MUGC district. Township Exhibit 6 will be a review letter from the Berks County Planning Commission dated today's date, February 18th, 2025, regarding its review of the proposed zoning ordinance amendment. The amendments that have been proposed, which are more fully and specifically contained within the actual text of the amendment, are as follows. Removal of certain uses permitted as of right in the mixed-use general commercial zoning district, including the warehouse and freight terminal uses, as well as the wholesale and distribution uses. The increase of the minimum width of driveways and drive aisles to 26 feet. the removal and or revision of the definitions of places of worship and religious uses, the addition of a definition for retreat center and regulations related thereto, the inclusion of expanded definitions and regulations with respect to renewable energy systems, the addition of provisions related to short-term rentals, the addition of definitions and provisions related to agritourism and agritainment, and the addition of provisions that are supplementary to all of the foregoing previously mentioned amendments. For the public's edification, the zoning ordinance text amendment that's being proposed tonight went through 13 drafts before tonight's hearing. I worked in collaboration with Jean Johnston, who is the township manager, and the township zoning officer, as well as with Steve Hoffman, who is an engineer from Great Valley Consultants, who does consulting work for the township. He was an integral part in providing me with the language that I needed and suggestions I needed for the more technical aspects of what is contained in the amendment. The Berks County Planning Commission was sent an early version of the zoning ordinance text amendment and did respond to that version with a written letter with suggestions, some of which were implemented into this final version and some of which were not. The Planning Commission also was sent the most recent version of the text amendment that is proposed for tonight, which did prompt a phone call between Ms. Johnston and a few members of the Berks County Planning Commission. And I understand that they discussed some of the provisions of the amendment, and ultimately the amendment was not revised based on that phone call. As I stated earlier, we did get a letter today at about 3:00 p.m. via email from the Berks County Planning Commission with another review letter of the amendment that's being proposed tonight. So that was marked as an exhibit, but the amendment is still on the table for tonight. Additionally, the Cumru Township Planning Commission was sent an early version of the amendment. I can attest that the Planning Commission reviewed the amendment and we had many discussions at just about every Planning Commission meeting from when the initial proposal was made late last year. So they also offered their suggestions and recommendations, some of which again were incorporated and some of which were not. So I just want to be clear, there are a lot of eyes on this amendment. And additionally, it was made available for public inspection. So I'm sure that some of the public, maybe even some of you here tonight, also reviewed the proposed amendment. Procedurally for this hearing, I'm going to take comment and deliberation from any township staff members and the Board of Commissioners. After that, we're going to open it up to public comment. This is not a zoning hearing, so there's not going to be anyone getting party status or anything like that. It's just the right of the public to comment on what they think about the amendment if they've reviewed it, and to give the board, your opinion if you have it. So with that, well, actually, if anyone from the public does want to speak on this, because it is being transcribed by the court reporter, I'd ask that you come up to the microphone, state your name and address for the record, and then provide your public comment. We would limit it to 3 minutes, but it doesn't look like there's a lot of you, so I'll let the president of the board determine when we'll cut you off. All right.
It looks like we all have beneficiaries.
Well, let's get if any of the commissioners or any of the township staff, Jean has any comment to make on the ordinance, I would welcome that first. I think that's a better order of procedure.
Any takers?
This is on the amendment itself, Kelsey.
Yep, this is on the zoning amendment.
It just really points of clarification more than anything. So like on page 7, section E, where you're talking about a contact person that has to be within a certain distance and respond within a certain time period and stuff like that. We feel like that's reasonable.
I do. This is typical language that's used in many other municipalities for short-term rentals because of issues that can arise with short-term rentals, thinking of Airbnbs and parties that are thrown and neighbors complaining. So it's really good to have a contact person within a very short distance.
Okay. Section B on page 11, number 6, where it talks about no light or sound can leave the boundaries a lot. Once again, kind of is that a reasonable type question? I don't imagine they're going to put like barriers or upright or anything like that at night time to block light out.
Again, this was language that, we had the engineer review, and that is typical for these types of ordinances, ordinance amendments in zoning. Because these types of entertainment can include things like wedding venues and parties, and we just wanted to make sure that there was not going to be excessive light or noise leaving the boundaries of the property. And in fact, I think the PLCB enforces, noise leaving the property as well. So they would have something to do with the noise portion of it.
Okay, I guess I just wanted to kind of make sure we're not painting Chief Winchester and his team into a corner, basically, where they're out there constantly.
Well, noise is one of the hardest provisions of any ordinance, whether it's contained in zoning or code, like, to enforce. Noise is incredibly hard to enforce. The only time that I've been involved with that, first of all, you have to have a calibrated decibel meter. And the only time I've successfully been involved in that was camping out on Hampshire Road overnight for several nights. If anyone remembers the gentleman who had a cannon out there, then was using it to scare birds at nights. It was completely disturbing the peace. Did keep the police department quite busy, but that's the kind of thing you have to do. I understand Mr. Miller's comment about that. I think what General and Chief of Police can correct me, but say there's a wedding venue, there's a noise complaint, the police go out there, if you please keep it down. Generally, people will be cooperative with that kind of thing.
Yes, that's correct. And that's sort of the neck, you're exactly right. I think the best way to attack a noise issue is usually, exactly how you described it, and then, it's a dangerous word, but reasonableness. So if the noise is at a level when it's an unreasonable time, that's usually when we can, enforce something, whether it be a noise or disorderly conduct sort of charge. But the LCD also does enforce that, and if we would get enough complaints relative to that venue or any specific venue that has any kind of liquor license to put regulations and different enforcement benchmarks that need to be held, or they'll get their license suspended.
Fair enough. Sticking on page 11, section E, permitted uses for agri-entertainment. How about tractor rides? I think that's a requirement at those kind of places that pay rides.
Can you point to the section you're looking at?
It's section E under permitted uses. Oh, does it go on to page 12? No.
So E3 you're looking at generally.
Yes.
And I think some of these are general enough that if they came to us and said, this is what we want to do, I think we could interpret it that way. And I think that's part of the problem with these ordinances. You can't fit every single possibility within them. But I think we can be flexible in the way that we interpret it.
Okay, I guess I'll rephrase. So there's nothing that would prevent them from doing hay rides that's in there.
In my opinion, no.
I don't think so. I think it could be subsumed under agriculturally related special events, tours, that, it has, if the attorney would pardon me for using more of a legalistic term, if it has a nexus with agriculturally related activities, we can subsume it under one of those.
Fair enough. I kind of thought that might be the case. Just two more things. Page 13, section H. More a question than anything else. Why do we limit the number of employees?
That's a great question. I think it's probably to make sure it doesn't end up something like Shocktoberfest where you have 1,000 people that are running around as employees. And it does give the leeway for additional part-time employees or volunteers to be permitted. So there is a mechanism by which an applicant could come in and ask for that permission and be granted that. If it was something that they needed for that use.
If they wanted to hire like a fifth full-time employee, they'd have to come in and ask to do that.
Technically, they would need a variance from the ordinance because this ordinance limits them to up to 4.
Do we want to go there?
That's up to the board.
I would suggest perhaps we just raise that number, let's say 10, 20, I don't know, we don't wanna get into a situation where residents had Shocktoberfest next door and when they bought their house, it was a pony farm. But, I think it's a good point, like, we don't wanna be overly proactively restrictive to like a private enterprise.
Right, and every time they want to hire somebody, they got to come back here. I mean, that seems a little overly restrictive. I'll use your words.
I think 4 is kind of low itself.
It would, you think 10, I mean, I can't imagine most of these operations have more than 10 full-time employees. Like for agritainment, like these aren't like large enterprises, like 10 full-time employees. Does that sound reasonable or unreasonable to anyone?
I actually have no idea. I'm more familiar with, from experience of family members being hired as part-time or temporary caterers at a place like this. This is referring to full-time employees. So I think if the board can decide what number you're comfortable with, that I can almost guarantee you, if it's a wedding venue and they're doing catering, they're going to hire a bunch of young people to do weekend catering on a Saturday and maybe clean up on a Sunday.
Or even enter into an agreement with a caterer that it's not their employees, it's some other entity's employees that are coming onto the property to do the work as an independent contractor. So there are a lot of ways to avoid the issue with the full-time employee limitation.
Yeah, that's exactly. I don't think contracting out help probably is an issue, but when I see something like one of them is like a farmer's market, I think of Weaver's down Route 10. They probably easily have more than 10 full-time employees, I would think. Or like a dairy ice cream bakery. I don't know that we have any of those in the township, but I think of Behringer's, however you're supposed to pronounce it, I always like Behringer's, but they probably easily surpass 4 very easily. So I think it warrants probably expanding that and probably a little restrictive in my mind.
Yeah, I guess the standpoint that I look at it is like, where's my choke point? Because like if they want to show up for a 5th, like I'm always going to say yes. If they show up for a 6th, I'm always going to say yes. I don't know where I start getting uncomfortable in all honesty. I mean, if Andy's saying 10, it looks like we should shake our head at 10. I mean, if that's the number, that's fine.
I don't know if that's the right number to me. It's a reasonably small enterprise at that stage still. It's also not restrictively small. Like I think a 10 full-time employees is moderately sized business that's operating, but beyond 10 full-time employees, it's also a round number. I don't have much scientific evidence to say it should be 10.
That's me. Do we need to do anything to change that, Kelsey?
Well, technically, if it's not a de minimis change in the ordinance, we would need to go through sending it back to the Berks County Planning Commission and the Township Planning Commission for review and having another hearing. In my opinion, I would consider the increase in employees probably a de minimis amendment. So I think we could probably just enact the ordinance with notation of that change to the proposed final.
I would consider it the minimum. And does it require post advertising?
I don't believe so, no.
Okay, one last thing. It's actually the same question. It just comes up in 2 different spots. So on page 13 and page 25, on page 17, it's number 9. on page 25, it's number 19. Once again, we were just a curiosity type thing. Why can't a ground mounted solar system be between between a building and the building right of way?
Sorry, I was thinking of from the last. The last issue,
State that again.
Yeah, page 17.9 and page 25.19. In both cases, it says you can't put a ground mounted solar system in between a building and the building right of way. Just curious as to why you couldn't do that.
So these were concepts that were given to me by the consultant engineer. I'm assuming it had something to do with the way it looks.
It's appearance, so it's partly appearance, it's partly accent, depending on where it is. It could inhibit, it could give, especially fire department, another hurdle to go through to get to the front of the property, the front of the house. And so, for example, we limit the height of fences in the front yard unless it's see-through. And of course, someone would say, oh, well, maybe you can see through. Since we don't have a drawing, we don't have an actual plan for what somebody would do. It's hard to predict all outcomes. I think it's reasonable to require these kind of structures not between the street right of way and the front of the building. That would mean it would be relegated to the side yard, rear yard. I don't know if Mr. Primer is here, if he would have an opinion on that as well. But I think that's where it's coming from. It's another thing in the way to get to the front of the property.
I don't know much about zoning compared to the rest of the room here, but it's about maintenance. If you put it between your right of way and your building, how are you going to maintain it if you have to get in there? It's something we run into with sewer mains all the time.
Yeah, and I think when I think about something like this, I think it's all about location too, right? Like the right of way on 222 business is quite different than the right of way somewhere out in the middle of the township and in the country. And so in those circumstances, like there's nothing precluding the landowner from seeking a variance like before. So I think it's probably like cover our butts situation where we, at the very least in a situation where if the location absolutely doesn't make sense, I think it's probably best that we have that.
Thank you. All right, I'm done.
Anything else from the Board of Commissioners, any staff members, if he wants to make any comments on the ordinance and procedure?
Only in regard to the Berks County Planning Commission's letter that we just received today. A lot of what they're talking about in their letter is more conceptual, and there's nothing right or nothing wrong. In regard to their last page about short-term rentals, they do ask or suggest a couple of practical things. One is the relegation of that use to specific areas. I frankly think that's rather hard to enforce, especially in interface areas. Another practical consideration is item number 3, whether there should be any limits to the number of days a short-term rental unit could be occupied if the unit has back-to-back rentals. So for instance, you have a really popular location that they've got a waiting list. Is there going to be a limit? My personal opinion is first come, first serve. And that's what I said to the Berks County Planning Commission, that it would really be, if an owner really thinks that they have that popular a location, they themselves can set a limit. I'll only rent it out a week at a time. So my recommendation is not to adjust that. Item number 4 about requiring contact information be updated annually. I don't know if the board's aware of this. We send a mailing every year to both home-based businesses and to non-home businesses. And one of the things that we do is we solicit them to update any alarm information that they want the police to have, if they have an alarm permit, or any other contact information. There are several things in this mailer, and we can certainly add, when we know about a short-term rental, we can certainly add short-term rental to that grouping and send that out, because essentially it is a home-based business of a sort. So I don't think we need to worry about the Berks County Planning Commission's last comment, because I think we can take care of that, so to speak.
Anything else from any members of the board, staff? Okay, then we can open it up to public comment if anybody wants to make a comment on the ordinance, their thoughts.
Did you have comment then? Yeah, if you want to come up and state your name and address, please.
Good evening, Ben Fisher, 24 Holly Lane. I like the way the township is updating the verbiage for the short-term rentals. I think that's a good thing to get the township up to date. And I think it's a good thing that you're doing that. I actually agree with the requirement of having a contact person. That can be very good. On page 5, you're talking about retreat centers. And in page 5, 11.4, it says the maximum number of guests at a retreat center shall be 4 guests for every acre of property. And the minimum lot size is 10 acres. So we're saying we're limiting a retreat center to 40 guests with that verbiage. So I'd like to recommend we look at that. I'm sure there's some kind of reason why that's in there, but I think it should be more lenient, maybe 10 to 20. We had a discussion in here about employees in a farm, and I mean, you can fit a lot more than 40 people in 10 acres, but you also got to consider parking spaces as well. So I know there's some kind of mathematical reason why, but in my opinion, that's a little bit too limiting. But by 10 acres, you want to do a retreat center, I want to have more than 40 people there. So also just want to address another thing. The previous 2021 commissioners obviously thought the MUGC was a good idea or would be. So it's fine that we're updating, we're changing. And I don't necessarily have any issue with the verbiage of it removing the warehouse. But I would encourage the township not to get predatory with previous approved plans that have met the requirements, that now all of a sudden the MUGC is stripped from them. They were making a business plan depending on it. And so as going forward, I would like to discourage predatory going after approved plans that are in the works based upon the time that it was passed in 2021. So again, that's all I have. Thank you. And work together.
Thank you, Ben.
Any other public comments? Let the record reflect that there's no one else from the public who has made a decision to speak. And so that would conclude the hearing on the zoning ordinance text amendment for tonight. The enactment of the ordinance has been advertised as being on the regularly scheduled agenda. So we're going to save the consideration of enactment for the regular meeting. That's only because it was advertised that way. Otherwise, we could have done it at the hearing, but the way it was advertised, we want to make sure we're following all the rules.
Start small.
Okay, the hearing on the amendment to the subdivision and land development ordinance has been scheduled to begin at 6:30. This is the time and place advertised and set aside for that hearing. Again, I'm going to, for the record, mark some exhibits. Township Exhibit 1 will be a copy of the proposed amendment to the Cumru Township subdivision and land development ordinance. Township Exhibit 2 will be the proof of publication of the notice of this hearing. For the record, the hearing was advertised on February 3rd, 2025 and February 10th, 2025 in the Reading Eagle. Township Exhibit 3 will be the affidavit of mailing of the proposed amendment to the Berks County Planning Commission and the Cumru Township Planning Commission. And Township Exhibit 4 will be a letter dated February 3rd, 2025 from the Berks County Planning Commission indicating that they have no adverse comments to make regarding the proposed amendment to the subdivision and land development ordinance. The amendment that is being proposed is to require two-way driveways serving non-residential uses to have a minimum width of 26 feet instead of 24 feet based on the previous ordinance. The proposed change was based on a recommendation by the fire chief due to certain access issues that emergency services have experienced in the past. So with that, again, the same procedure, I'd open it up to the board or to any township staff to make any comment that they'd like to regarding this amendment. Let the record reflect that nobody wished to speak from the board or the township staff. Is there anyone from the public who wishes to speak regarding this subdivision and land development ordinance amendment? Okay, let the record reflect that no one from the public volunteered to speak. And so again, the enactment of this ordinance will be on the board's agenda at its regularly scheduled meeting beginning at 7 p.m. tonight. And that will conclude this hearing.